Welcome to the ICAHN Institute for Board Education. I'm Pat Scow, the Executive Director of the Illinois Critical Access Hospital Network. I'm excited once again to bring to you the series on board education for physician contracting and the legal ramification of contracting with medical providers. The first series was on the role and responsibilities and the details that go into physician contracting. Remember, physician contracting includes nurse practitioners, physician assistants, nurse midwives, others that are involved in the medical provider role. The second part series, which we'll cover today, is on the legal ramifications, those legal details that we need to know about when we look at and evaluate contracts. You as board members have that fiduciary responsibilities to ensure that these contracts are executed well and that they cover the responsibilities that are required of a hospital or the organization. So I'm pleased that Katie Anderson can once again provide that education for us. Katie is on council with Heyl Royster, Volker & Allen and is located in the Champaign office. She brings a wealth of healthcare law experience and has done a lot of work with malpractice review and litigation and has served as in-house counsel for hospital organization. So thank you, Katie, once again for being here and look forward to your presentation.
Thanks, Pat. You'll recall that in the last video, we talked about the various types of contractual arrangements that hospitals can have with physicians. Today, I'd like to talk to you about the two most important federal statutes that govern those contractual arrangements. Now, there are two main federal statutes that apply to physician contracts. There are more than two, but I'm going to talk today about what I consider to be the two most important statutes. The first is the Stark Law. This is a federal statute that imposes civil penalties for any violations, and this applies only to physician contracts. The second statute is the Anti-Kickback Statute, or AKS. Now, this statute imposes criminal penalties for any violations, and it applies to all contracts with providers. So that would include physician contracts, but it also includes mid-level contracts. So your contracts with physician assistants, contracts with nurse practitioners, all of those are regulated by the AKS statute. Now, it's important to understand as we discuss these statutes how hospitals are compensated for their services. So there are typically two components to any services that a hospital provides. There's going to be the professional component, which is assigned to the services provided by the physician or by the mid-level. There's also the technical component. So this charge takes into account all of the technical items that go into the service. For example, the cost of the X-ray machine, the cost of the X-ray technician, the use of the hospital facilities. So typically for every service that a hospital provides, there is both a physician or a professional component and a technical component. Now, when hospitals compensate physicians, years ago, the federal government recognized a need to control the amount of compensation paid to physicians so that hospitals do not compensate physicians in exchange for referrals to that hospital. And I'll tell you what I mean by that. Let's say a patient goes to see Dr. Smith in the office, and Dr. Smith decides that that patient needs radiology studies or lab studies. The physician then has a choice where to send that patient to have those tests done. So let's say Dr. Smith refers to your hospital and tells the patient, go have your blood drawn at the hospital's lab. So that's what's called a referral. The physician is telling the patient to go to the hospital and have a test done. The federal government recognizes that it wants patients to have the ability to choose where they have those services that the physician recommends performed. In the past, there were situations where hospitals were essentially paying inflated compensation to physicians in exchange for those referrals. So in other words, the hospital would make the compensation to a physician more attractive with the expectation that the physician would then send that patient to the hospital for all of its ancillary services like radiology or lab, or even if a patient was going to be admitted to the hospital, the agreement would be that the physician would send that patient to the hospital. So in order to control what the government felt was inflated compensation that was being paid to the physicians, these various statutes were enacted. And essentially, it makes it illegal for a hospital to compensate a physician in exchange for a referral. Now, you might be asking yourself, well, physicians do that all the time. And that's true. And that's because under both of these statutes, there are various exceptions or what's called safe harbors that allow there to be what's called a financial relationship between the hospital and the physician. So in other words, it is legal to pay a physician for services. However, that arrangement, whether it's an employment agreement or a professional services agreement, has to meet certain requirements or fall into an exception. So some of the more technical requirements are things like, number one, the agreement must be in writing. It has to be signed by both the parties. It has to be for services to be provided in the future. So in other words, you cannot have a situation where there was an agreement among the parties and then they sign an agreement that retrospectively covers what they've already done. The agreement has to be for services to be provided in the future by that physician. The contract must be at least a year in duration. So those are some of the more technical requirements that are required under these statutes. But perhaps the biggest requirement is that the services must be within fair market value and they must be commercially reasonable. Now, you can imagine that terms like fair market value and commercially reasonable may be subject to interpretation, and you'd be correct. And that is perhaps one of the most confusing and difficult areas in making sure that your contracts are compliant with these statutes, is determining what exactly is something that's commercially reasonable and what is something that's within fair market value. Luckily, the government has provided guidance to us in terms of what it considers to be fair market value and examples of agreements that are for fair market value or are commercially reasonable. So some of the things that are available to hospitals to help it determine whether the compensation paid to a physician is within fair market value are things like, for example, benchmark data. So there are various companies that provide benchmark data to hospitals. One of the most common and popular is MGMA. Now, what this company does is provide data that they have compiled from all across the country in terms of what a particular specialty is paid in that particular area of the country. So for example, MGMA will provide a figure for what general surgeons in the Midwest are typically compensated, or in the Northeast, or the Southwest, or even nationally. Hospitals can then use this data to compare what it's paying its physicians to make sure that it's in line with what the market is paying. There's also factors that can be taken into consideration, for example, the experience level of the physician. You are not going to pay a person who is directly out of their residency or their internship as much as you would pay somebody who's been practicing for 20 years. There's also the need of that particular specialty. So for example, if you have been trying to recruit a physician for 3 years and have had very much difficulty bringing someone into your area, that's something that can be taken into account when considering whether something is commercially reasonable or fair market value. You'll recall that at the beginning of the presentation, I talked about some of the challenges facing hospitals in this area, namely recruitment. I've seen hospitals recruit years and years for a particular specialty or for a particular physician to try to get them to this area. So as a result, it can be tempting for a hospital to offer a very attractive compensation package to that physician to come to the area. But again, we have to be careful that we are doing it consistent with the federal regulations regarding these contractual arrangements. And again, one of the biggest areas of scrutiny is whether the compensation paid to that physician is reasonable. Other things to consider is how many physicians are currently practicing in the area. So let's take the example of primary care or even cardiology. If you've got one primary care physician who is essentially going to be on call 24 hours or is the only provider in that area, that is worth something in terms of the amount that you have to compensate that physician. contrast that with somebody who is perhaps part of a group of 5. So you've got 4 other physicians in addition to the one physician you are trying to recruit who can provide coverage, who can provide backup, do on-call coverage. That's something to take into consideration when you are figuring out the compensation paid to a physician. I recommend that even once you have an agreement established with a physician or a group, that you regularly review that agreement. So earlier in the presentation, we talked about the duration of these contracts, and they're typically multi-year contracts. And again, we know that one of the requirements is that the agreement has to be at least 1 year in length. However, I think it's a good idea to limit the number of years in the agreement, so that way the parties are forced at the end of the agreement, before they negotiate a new contract or enter into a new contract, to look at the terms and make sure that everything is still consistent with fair market value and make sure that things are still commercially reasonable. And again, we do that by looking at factors to see, is that physician still providing the same level of services? Has the market changed in terms of what we are compensating these individuals? These are all items that you need to take into account when you are reviewing a physician contract. Another item that is closely scrutinized by the federal government is medical director agreements. Earlier, I described this arrangement where you have a physician that is providing some administrative duties or functions to the hospital regarding a particular service line or area. So, in a medical director agreement, we want to make sure that the physician is actually performing the duties that they are contracted to perform. And so my recommendation, and what the federal government likes to see, is that the physician is submitting timesheets for the amount of time that they're spending on these administrative duties. And so if you think about that, logically it makes sense. We know that physicians are going to provide clinical services to their patients, but then for the extra time that they're spending on these medical director duties, these administrative functions, so for example, reviewing regulations to make sure that those services are in compliance with what's being regulated, if the medical director is providing guidance to the department in terms of what are best practices, reviewing the services provided by people in that department. These are all things that a medical director does. But we know that it's in addition to the clinical duties that the physician is performing, and we want to make sure that they're actually performing those duties before we compensate them for those services. So typically we like to recommend that physicians complete timesheets, which basically set forth the amount of time that they spend on something and what they actually did. They then turn those into the hospital, who knows, okay, Dr. Smith did 5 hours of work as the medical director of his particular area, and we know that we compensate him X amount of dollars per hour that he spends on these duties. So those are some of the things that hospitals can do to ensure that if the government ever took a look at any of the agreements or compensation paid to a physician, that the hospital is making sure that the physician is actually performing the duties that they're contracted to provide. So I hope this has been helpful in terms of understanding a little more why physician contracts are so important, what types of contracts there are, and the various regulations and statutes that govern those contracts. Thank you.